Here's a big story from today that almost nobody's talking about, but it could end up reshaping the federal cannabis law. A group of Massachusetts marijuana businesses is asking the U.S. Supreme Court to take a case called Canna Provisions versus Bondi, where they're challenging the constitutionality of the federal marijuana ban under the Controlled Substances Act. They want the court to rethink its 2005 decision in Gonzalez versus Reich, which said Congress can criminalize marijuana even when everything happens inside a single state. And today, Trump's Justice Department did something interesting. Instead of filing a brief to defend federal prohibition at this stage, U.S. Solicitor General D. Sauer told the court the government waives its right to file a response to the petition in this case unless requested to do so by the court. That doesn't mean the DOJ now loves legalization. It does mean they're choosing not to actively argue against this petition right now unless the justices specifically ask for it. So what are these cannabis companies arguing? They say the world has completely changed since Reich was decided in 2005. Back then, only a handful of states had legalized some form of marijuana. Today, 38 states have legalized cannabis in some form, medical, adult use, or both. Since 2014, Congress has blocked DOJ from spending money to go after state legal medical programs, and the DOJ policy has been to largely stand down on enforcement against state-regulated medical and even adult use markets. That's how the plaintiffs describe it in their brief. A long period of non-enforcement that severs the link between federal goals and state-regulated weed. Their basic point is, if states have legalized, Congress is trying the DOJ's hand on enforcement, and the feds are mostly tolerating state markets anyway. Then the old logic behind treating all marijuana as a federal crime no longer makes sense. And there's a twist. Back in 2021, Justice Clarence Thomas himself questioned whether the federal ban is still necessary or proper, while in the current system a half-in, half-out regime that both tolerates and forbids local marijuana use, and strains basic principles of federalism. So this isn't just a left-wing talking point. Even one of the most conservative justices has said the regime is a mess. Now, to be clear, the Supreme Court hasn't agreed to hear the case yet. 4 justices would have to vote to take it. The DOJ could still be forced to respond later if the court asks, but the Trump DOJ choosing not to automatically defend the federal ban at this first step is a signal. They are not racing to protect a prohibition that most states and most voters have already moved past. If the court does take this up and decides Reich was wrong or needs to be narrowed, it could blow a huge hole in federal marijuana prohibition and shift a real power over cannabis back to the states. If this helps you understand what's actually going on with federal weed laws, hit like and subscribe. It really helps push this kind of content out to more people who care about these things. And I want to hear from you. Do you think the Supreme Court should let states decide marijuana policy or keep a nationwide federal ban in place? Drop your take in the comments.